Hi, I'm Paul Ingbertson. I'm a full-time artist and a teacher of painting. I also served as a New Hampshire state representative for 6 terms beginning in 2003. I'm one of a number of concerned citizens, including other former and current New Hampshire state legislators, who are very concerned about the unprecedented usurpation of legislative authority by our Supreme Court in the now infamous Claremont decisions of 1993 and 1997. We've come together to produce a series of podcasts that will lay out the facts and evidence for your consideration. We'll be hearing from some of the best legal minds in our state who have followed the issue from the beginning. Our goal is to create public awareness of the serious separation of powers implications of the Claremont decisions, with the hope of generating active public resistance to it and any future such judicial overreach. Today, I'm sitting down with Greg Sorg, a New Hampshire attorney and a former state representative with whom I served during my time in the House. Greg has successfully filed amicus briefs with the Supreme Court on related cases. The reason for these podcasts is because we know that it's going to require action on the part of the legislature to take back powers that have been removed by the sole authority of the courts. They just make claims on our powers and take them and start dictating education policy. This is not about education. This is about the power of the people. So knowing that, what we're trying to do here today with these podcasts is, first of all, to establish the basis of the problem, to really show that this is legitimately a problem to the court of the people, to the people. This is the court we care about right now. And so first of all, Greg and Rick are going to come in there and establish the problem. But what we're going to then be doing is we're going to be broadcasting this and creating a wind for you guys, a tailwind. And you guys, you're going to have bills like HCR 14 that came up back in what year was that? 2003. It's coming up this year, the same bill. It says a resolution declaring the New Hampshire Supreme Court's Claremont decisions to be an unconstitutional violation of the separation of powers mandate under Part 1, Article 37. We're trying to create a tailwind for you guys. It's not an organized political thing. I'm just saying that now, but for whatever you guys can do. That's just one thing that I just learned is coming up. I think Greg is related to, Greg Hill might be sponsoring that. So, have it clear in your mind that what we're doing with these podcasts is all about marketing. It's all about getting our noise out there with the theory that Jefferson is right. That or it was Dirksen who said when they feel the heat, they see the light. But Jefferson's comment was, he says, well, ultimately you won't be able to control tyranny probably except through public opinion. So we're trying to educate the public and inform them and get them. If you don't hear phone calls from people, it's not because we're not trying to be irritating. So I'm going to introduce Mr. Gregory Sorg, Gregory M. Sorg. Our first speaker is attorney and former state representative Greg Sorg of Easton. Greg's undergraduate degree is a BA in history from the University of Maryland, concentrating in the American colonial, revolutionary, and post-revolutionary constitutional periods. Who could be better for us? He holds a Juris Doctor degree from Washington and Lee University School of Law, and has been a member of the New Hampshire Bar since 1981. He operates a small one-man real estate practice from his home in the wilds of Easton in northern Grafton County. Greg is chagrined to admit that his interest in New Hampshire state politics dates only from January 1994, when he first read the Supreme Court's opinion in the case that has come to be known as Claremont 1, and recognized it for the barely disguised unconstitutional intrusion by the judiciary into the legislature's policymaking authority that it was and still is. He saw it as a threat to the separation of powers with implications far beyond education. He believed that unless overruled or repudiated, it would serve as a precedent for all manner of further judicial interventions into any area of policy upon which the Supreme Court arbitrarily decided to confer constitutional status. Greg's most recent contribution to the fight to restore the Supreme Court to constitutional legitimacy has been the filing of an amicus brief on behalf of serving members of the House and Senate. I think there were 31 of them, in the course of the 2019 appeal of the so-called Conval school funding case, and to file follow-up amicus pleadings in the current 2024 appeal of the same case. Greg wants it known that his quarter century of activity in this fight, which has included 4 terms in the House, I think I was with you in all of those, has been entirely as a volunteer at his own expense of time, money, and lost business. He wants it known that he has received no dark money from billionaires as a hand-picked lawmaker who will do their bidding in the war against public schools, and that if anyone knows where he can apply for some of that money, please let him know. And with that, Mr. Sorg, thank you very much for being here. This is hugely important.
Thanks, Paul. The reason we're here and the reason this podcast is being made is because the Claremont saga, which began in December of 1993, almost 31 years ago to the day, is quickly coming to its head, which could have been easily anticipated back then, which is that the Superior Court has ruled that the legislature must come up with what amounts to $500 million to supplement what it's already funding for education. And the plaintiff school districts are asking the Supreme Court to issue an order to the legislature to raise that money. The separation of powers implications of that are painfully obvious, but they should have been painfully obvious 30 years ago. This should have been acted upon right from the beginning, but here we are confronted with it now. How did we get to this point? Well, that's what I'm here to try to acquaint you and the listeners to this podcast of. Back on December 30th, 1993, the Supreme Court ruled in the case of Claremont School District et al. Versus Governor, which is now known as Claremont 1, that the state has an obligation, constitutional obligation, to provide an adequate education for which the state must pay in full. The exact words are short and sweet. It is this: we hold that Part 2, Article 83 imposes a duty on the state to provide a constitutionally adequate education to every educable child in the public schools in New Hampshire and to guarantee adequate funding. Now, this right, this fundamental right as the court called it, had gone unnoticed for 200 years. It was hidden in the wording of Article 83 of Part 2 of the Constitution. Here are those words. It shall be the duty of the legislators and magistrates in all future periods of this government to cherish the interest of all seminaries and public schools. And that's it. And I'll hold up to you, this is Article 83 in full. It's really a catch-all provision in the Constitution. And if you can see the highlighted portion, those are the words I just read. They're just right there towards the top, and they're a very small portion. And there's much more context to that than the Supreme Court would let you know. But hidden in that wording is the word cherish, which apparently to the court means pay for, and the duty of the legislators is to pay it. Apparently that must be a personal obligation of the legislators, because it says, Article 83 says legislators, it doesn't say legislature. A rather significant difference, I think. And it begs the question, why were the authors of the Constitution so obscure? I mean, were they semi-literate or just plain dumb? I mean, couldn't they have just said the legislature shall fund or the legislature shall pay for? Well, never mind. The Claremont judges figured it out. And they said later on in the Claremont opinion, we do not construe the terms shall be the duty to cherish in our Constitution as merely a statement of aspiration. The language commands in no uncertain terms that the state provide an education to all its citizens and that it supports all public schools. So in doing that, the court corrected the errors of 2 centuries, meaning that all our children will all benefit. So what does the Claremont 1 decision say about the court? Well, to supporters of this decision, it means this is the most brilliant court ever. I mean, the court that decided Claremont knew more than all people that came before them. They knew more than the authors and ratifiers of the Constitution in 1784, some of whom presumably served in the legislature afterward. The court knew more than all legislators for 200 years afterwards. It knew more than all the judges that have served in the 200 years after ratification of the Constitution. And it certainly knew more than Superior Court Judge George Manias, who had decided the Claremont 1 case when it was in the Merrimack County Superior Court. What Judge Manias had said was, New Hampshire's encouragement of literature clause, that's Article 83, contains no language regarding equity, uniformity, or even adequacy of education. Thus, the New Hampshire Constitution imposes no qualitative standard of education which must be met. Likewise, the New Hampshire Constitution imposes no quantifiable financial duty regarding education. There is no mention of funding or even of providing or maintaining education. The only duty set forth is the amorphous duty to cherish public schools and to encourage private and public institutions. But the judge was apparently not equal to the brilliance of the 5 legal scholars that then sat on the Supreme Court. Now I'm engaging in mockery in this, but the problem is this has to be the view of the supporters of Claremont 1, that the judges of the Claremont Court, 200 years removed from the events, knew more than the contemporaries of the ratification of our Constitution about what it meant. Perhaps the supporters of the Claremont decision believe in the concept of the living Constitution, whereby the meaning changes to keep current with the times. The courts decide on what changes are needed. Never mind that inherently establishing future policy is a legislative concern, and the judicial function is supposed to be retrospective, commenting on the law that has already been passed, not imposing the law that's going to be followed in the future. That's the legislature's job. But according to those who support the theory of the living Constitution, that's the judiciary's job also. And why not? Judges, let's face it, judges are smarter than legislators. That's the view of the supporters of Claremont. Now, to me, my view of the Claremont court, based on this decision, is that this was the most lawless court ever. And I remember very clearly my first reaction when I read the Claremont decision in January of 1994. I said to myself, if the court can get away with this, it can get away with anything. Of all the opinions I'd ever read, U.S. Supreme Court or state Supreme Court, this was the most cynical, the most intellectually dishonest, the most obviously result-driven, and the most ultimately destructive, as we're about to find out. So let's look at the source of this divergence. And here I'm a little hesitant because I want to go back fairly far here to get to the root of the problem. And it's not just back to 1993 when Claremont came out, and it's not even to 1784 when the Constitution was ratified, but back to 1701 and across the ocean in Great Britain to the bill known as the Act of Settlement, which resettled the line of succession to the English crown. Those of you who have studied some English history know that in 1689, when the Catholic King James II vacated England, the Parliament declared the crown vacated, and they passed the Crown and Parliament Recognition Act, which established succession with James being gone. And it settled the succession in the Protestant Stuart line. And conveniently, his elder daughter Mary was Protestant. She was 27 years old, and she was married to William of Orange, the stadtholder of Holland, and they became monarchs, joint monarchs as William and Mary. And the act provided that if they failed to have issue, then the crown would pass to Mary's younger sister Anne, who was then 24 years old and had many children before and after that. But by 1701, the picture had changed, and Queen Mary had died childless at the age of 32. King William was in poor health. Princess Anne, who was then 36 years old, was also in poor health. And her last surviving child, William, the Duke of Gloucester, had died at the age of 11. There was no successor to Anne. And the most direct Stuarts who would follow were from collateral elders were Catholic. So Parliament settled succession to the British crown in Anne, and upon her death in the Electress Sophia of Hanover, who was, I think, a granddaughter of King James I, and also safely Protestant, and she had several children, very healthy, who were also Protestant, and that led to the succession of the four Georges in the 18th century. And I mention all this because it obviously has no relevance to Claremont, but just to point out that this was a very important constitutional settlement, and it had other parts to it that were also put in. One of them was that the judges of the courts were to serve, quote, during good behavior, close quote. This is a milestone in the development of Western civilization, the development of constitutional standards and civil law. Because prior to 1701, though it had become traditional to respect the decisions of judges, they were nevertheless subject to doubt or taint, particularly where the king was a party to them, because the judges were appointed by the monarch and served at the monarch's pleasure. And this had serious consequences in the 17th century in the struggle between Parliament and the kings, which dominated much of that century, where close constitutional decisions, usually on the king's ability to levy taxes, would go to the king. It was frustrating to Parliament because they were hoping to starve the king out. Right? The king would come to heel. If he wanted money, he'd have to go to Parliament, and Parliament would demand concessions. And King Charles I ruled for many years without having to deal with that because the courts were so friendly to him. So Parliament dealt with that in the Act of Settlement, made the judiciary independent. The judges would not serve at the pleasure of Parliament, which would simply change the source of the problem, but would be in essentially for life subject to address by both houses of Parliament. So Parliament took this momentous step. Judges were to be independent of politics, and decisions would be truly disinterested on the merits, free from political pressure. That was the goal. And this is known as judicial independence. Judicial independence is an anomaly in a system of government based upon the consent of the governed, because decisional independence carries a danger. And the danger is that judges who are free of influence of politics being brought to bear on themselves may interject their own politics into their decisions, for which there is no appeal or easy remedy. And this is what's happened in the Claremont cases. Now let's move up to 1784 and consider the structure of the Constitution. The Constitution is divided, as you probably know, into two parts. Part one is styled the Bill of Rights. Part two is styled form of government. The location or source of this supposed fundamental right to an adequate education is found in Part 2, Form of Government, in Article 83. An actual education-related right does exist, but it's in Part 1, the Bill of Rights, where it belongs, and it's found at Article 6, about which I'll be speaking in just a moment. So if a substantive individual right exists in the Constitution, it belongs, because of the structure of the Constitution, in Part 1. Rights of persons are not in Part 2. And Part 1, as I've said, does have an education-related right, or at least it did until it was amended into incoherence in 1968, where it was truncated. But Article 6 of Part 1 originally read in relevant part. What this does is provide for the right to education to be held by the localities, but empowers the legislature to require them to provide education. We do hereby fully empower the legislature to authorize from time to time the several towns, parishes, bodies corporate, or religious societies within the state to make adequate provision at their own expense for the support and maintenance of public Protestant teachers of piety, religion, and morality. Provided, nevertheless, that the several towns, parishes, bodies corporate, or religious societies shall at all times have the exclusive right of electing their own public teachers and of contracting with them for their support and maintenance. Article 6 of Part 1 is never mentioned in any of the Claremont decisions. I mentioned it in our 2020 amicus brief. I discussed it in detail, in fact, over 15 pages, I think. And the court and both parties ignored it. My research showed that it never came up at all in the course of the entire 1992-93 Claremont 1 litigation. The plaintiffs, I'm guessing, suppressed it because I can't imagine that they did their research in preparing for this school funding litigation without discovering Article 6 of Part 1. But they never raised it. And the Attorney General just didn't do the research that would have resulted in it being found. And I'm guessing they didn't do it because the case to them seemed simple. It seemed a slam dunk. Article 83 wording was, as Judge Manias had concluded in the Merrimack County Superior Court, hortatory. That was the word he used. I'd never seen that word anywhere before. I've never seen it in any other context, in fact. Hortatory, which means aspirational. So the Attorney General saw no need to explore any further and briefed the case without any reference to it. And for which I don't really blame them, because considering how easy this case must have looked when it went to the Supreme Court, I was kind of surprised at how good and how thorough the brief that the Attorney General filed was. But I went through the three banker boxes of materials that the Attorney General's office maintained of those cases. They were very kindly provided to me by then Solicitor General Dan Will. And as I suspected, there was no mention anywhere of Article 6. And this is important for giving a true interpretation of what Article 83 means, because you need to show what the interplay was between Article 6 and Article 83. Under Article 6 of Part 1 in the Bill of Rights, localities have full authority to provide and control education at their own expense, while the legislators, in accordance with Article 83 of Part 2, have as their maximum constitutional duty the right to require the localities to provide education locally at local expense. The legislators can do more at their option. They can legislate state funding, which the localities have the right to refuse. But constitutionally, the legislature is not required to fund education, but it can obligate the localities to do so. That's the extent of the Constitution on the subject. Now, if that seems strange to you, you need to remember that the New Hampshire Constitution is an 18th century document, and 18th century Americans wanted education kept local. Article 6 and Article 83 were a compromise. Article 6 provided local control at local expense guaranteed as a right, but Article 83 provided that the state can mandate that it be provided, because some localities in those days would not do so if they didn't have to. They were overwhelmingly rural, and they might conclude that you don't need any reading, writing, and arithmetic to be able to be a farmer or to be a logger, and they wouldn't provide education. But the authors of the Constitution considered education to be important, and so they wanted to have a way to require the localities to provide it, and that's what Article 83 was for. Claremont turns this constitutional arrangement 180 degrees around. The intent was to keep and protect local control of education. What the court did was turn it into 100% state control, because funding means control. School districts that are the plaintiffs in the matter ought to be wary of what they've done. You know, it's a species of be careful what you wish for, because once the state has required to fund education 100%, with it will go local control of education. He who pays the piper, right? And I can remember, you referenced the late, great Representative Mirsky. I can remember him telling me on several occasions that in connection with this Claremont situation that local school boards are dead men walking. They don't know it, because what they're doing, the logical consequence of what they're doing is that they will have no authority anymore. They will not be paying the bills. and they will just have to do the bidding of the legislature. And I don't think that's really their intention. They want it both ways. They want the state to pay, but they want the control. And we're seeing what that's resulting in. With the fraction the state pays now, costs are just running away. Enrollments are decreasing, and yet funding, especially for positions in the administration of the schools, are skyrocketing. But that's someone else's bailiwick to discuss, not mine. I'm not concerned with education policy so much as to who shall determine the education policy, and it ought to be the legislature. The founding generation, as any of you who have read the works of the founding generation know, they were very facile with words to an enviable extent. And yet the Constitution at Article 83, Part 2, says that legislators shall cherish the interests of the public schools. It does not say shall pay for or fund, words and phrases that were certainly in the lexicon of the 18th century. One last thing about the Constitution. Nothing in the Constitution says that the court's understanding of the Constitution takes precedence over the legislature's, or is final and binding on the legislature. Nothing in the Constitution places the Supreme Court's opinions beyond the reach of scrutiny for substance, in the position of being self-proven, that is, not subject to legislative scrutiny for the quality of the scholarship and its consistency with the Constitution. They are not correct and true merely because the state is saying it's true. Not subject to the need to be persuasive, deserving more from legislature than the benefit of any doubt and respectful consideration. In other words, there's no counterpart to the doctrine of papal infallibility in the Constitution. Judicial review is a doctrine that is not mandated, and judicial review and judicial independence are not the same thing. The source of the power of judicial review, which again is that the opinions of the Supreme Court are final and binding on the entire government, is not in the Constitution, and it's not in the common law tradition, but it comes about merely through declarations by the courts themselves on the federal level, in the famous case of Marbury versus Madison, and in the state, most notably in the case of State versus LaFrance in 1983. And State v. LaFrance, the timing of it is a matter of interest to me because it's so breathtaking in its scope. And it's something that I don't think ever would have been attempted by the court in the days before ratification of Article 72A of Part 2, which made the Supreme and Superior Courts constitutional courts. Because in the past, when the highest courts in the state had gone rogue in the opinion of the legislature would deal with that situation by simply dissolving the courts. It would abolish the courts, thereby putting the judges out of work, and then would immediately reconstitute the courts under different names, and then restaff the courts. They pulled that trick 5 or 6 times during the 19th century, and they were a very effective check on judicial excess. But when 72A was ratified in 1966, that avenue of control over the judiciary was gone. The courts are essentially free of any control now. We're supposed to be a system of checks and balances. Well, tell me what the check is on the courts. There isn't one anymore. They've been, through the constitutional amendments in 1966, which I'm sure were well-intentioned, have deprived the other 2 branches of the government of any ability to control the courts. They're controlled only by such deference as they wish to condescend to give to the other branches of the government. That's the problem we have now. Looking at the Claremont decision itself, the court adopted as its standard for review a historiological approach in order to decide the issue of whether there was a right to a state-funded education held by all school-age children. And the approach the court took was this: standard of review chosen by the Supreme Court in Claremont 1. In interpreting an article of our Constitution, we will give the words the same meaning that they must have had to the electorate on the date the vote was cast. In doing so, we must place ourselves as nearly as possible in the situation of the parties at the time the instrument was made, that we may gather their intention from the language used, viewed in the light of the surrounding circumstances. That was the court's choice of a standard of review. So what was the history of education funding in the state that they drew upon? Well, there was no provincial-wide funding in the colonial period of education. There was no state funding of education at the time of ratification of the Constitution. There was no state funding of education in the years immediately following ratification. In fact, there was no state funding of education at all until the 1850s, 70 years after ratification of the Constitution. The court ignored all this historical evidence despite the standard of review it had itself established. Now, the best evidence would have been what the legislature or the colonial assembly had actually done. And in particular, the education funding law of 1789 would have been very enlightening had the court chosen to mention it. Perhaps they didn't know about it, but I truly suspect they did, and they ignored it. They couldn't have done the research what research they did without discovering all the evidence that didn't support what they were doing. That's why this decision is particularly nefarious. It was so intellectually dishonest. They stumbled over the truth and just kept right on going as if it wasn't there. But the education funding law of 1789, which was the first funding law established after ratification of the Constitution with Article 83 right in the Constitution, what did the state do? It imposed mandates to the localities to provide education and how much they should pay for it. The localities, not the state. The localities, the education mandates the state was making were to be fully funded by the localities. This is exactly consistent with the connection between Article 6 of Part 1 and Article 83 of Part 2 that I've just described. Education funding and policy after the 1850s was a mix of state and local revenue sources, much as we have today, just as the interplay of Article 86 and Article 83 anticipated and allowed. And the constitutionality of any of this was unquestioned until the court in Claremont 1 in 1993, a century and a half later, said it had all been unconstitutional. In short, the court's decision in Claremont 1 fails to pass constitutional muster on the basis of the court's own chosen standard of review. So to summarize what Claremont 1 did, what had for 200 years been a matter of policy give and take within the legislature became a constitutional imperative, thereby interjecting the judicial branch into the legislative branch's constitutional territory. The court became self-appointed education czars, able to sidestep the messy legislative process and ensure that final policy choices came from on high by judicial oligarchs who were impatient with the pace of progress that the legislature was making. After all, they're too slow, they're backward. They're not as smart as us. They don't care as much as we do. You know the familiar progressive mantras. So how is a policy-driven decision by the state's highest court to be remedied? I suggest by critical review of its written opinions and by repudiation of written opinions that are obviously policy-driven. Supreme Court judges, as we know, render written opinions. Why have written opinions if not to ensure that these rulings are free of politics? That, in other words, that the courts are abiding by their half of the bargain made in 1701. You get to make your decisions free of external influence, but you must keep politics out of your decisions. That was the sort of the social contract between the courts and Parliament in 1701. if not to permit legislative repudiation if found to be motivated by politics, if it's demonstrably constitutionally unsound, what's the point of having written opinions? There must be consequences to written opinions that are politically motivated in order not to create, but to avoid a constitutional crisis. A lot of people don't realize it, but we've been in a constitutional crisis for 30 years. We're told we mustn't fail to abide by whatever the court says because that would cause a constitutional crisis. But the court has caused the constitutional crisis by intruding into your territory. Suppose the state, during the middle of a trial taking place in the Merrimack County Superior Court, were to pass a law that declared that the defendant was guilty and was to be sentenced to life in prison. What would the court do with that? They would just ignore it. They'd laugh it off and disregard it. Why doesn't that work both ways? In fact, for what I've just suggested the legislature do, there is actual historical precedence. I think it was called a bill of pains and penalties. This was a fairly common thing back in the day. So there actually is precedent for doing that. But why shouldn't it work both ways? If the legislature were to pass a bill that is obviously a judicial act, why is it not forbidden for the court to render a judgment which is in fact a legislative act? But what's happened that's created this crisis is the court went a little too far in their quest to be the readers of the Delphic Oracle and to dictate to the state, because they've made an opinion, they rendered an opinion in Claremont that the state pay a huge state expense which the people are unwilling to assent to. And what would be the effect of one rejection of a court opinion that overstepped its constitutional bounds? Well, the judges would pick future quarrels more carefully. They would be more circumspect. That's it. The legislature has the power of the purse. The legislature can't be required by a coordinate branch of the government to make appropriations. That would itself be a violation of express law found in Part 2 of the Constitution. And I would suggest, too, that rejection of judicial review is not the outlier. It's consistent with the pre-revolutionary view of relations between the legislature and the judiciary. It's consistent with the Constitution's structure. It's consistent with early Republic opinions expressed in such things as New Hampshire's 10-Pound Act cases of 1786, in the writings of Jefferson and Madison, in Andrew Jackson's 1832 veto of the bank bill, which contains a classic statement of rejection of the doctrine of judicial review. And also in Lincoln's 1861 first inaugural address. And that's of interest to me in particular because it has some resonance here in the Claremont situation. Lincoln made it plain in his inaugural address that he was going to disregard the Dred Scott decision, I think you all heard of, which basically said, as a matter of federal constitutional law, the black man had no rights that the white man was bound to respect. And in responding to that in his inaugural address, Lincoln said, "The candid citizen must confess that if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the instant they are made in ordinary litigation between parties and personal actions, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal." And that resonates with me because here we have going on in the Supreme Court right now a case which vitally affects the authority of the legislature, and yet the legislature is not even a party to it. In 1993, the Supreme Court in effect yelled jump, and right now the school districts and the Attorney General are contending over how high, and that's it. If the legislature had been involved in this right from the beginning, the legislature could have asserted before the court in that case and any subsequent cases that came along that the court should overrule Claremont 1 instead of conceding it to be legitimate precedent and then trying to cope with it, which we've been trying to do for 30 years. The legislature has been trying to juggle these two balls. The court says you have to bear this huge new expense, and our voters are telling us they don't want this big expense. We don't want to be like the other states. We don't want a broad-based tax. We don't want a sales tax. We don't want an income tax. But how could you comply with the implications of the Claremont decisions without doing that? And that's been what the constitutional crisis has been for the last 30 years. The court has said you must do this, and the legislature has been saying in effect, has been saying we don't want to do this. What I think are the historical outliers are blindly accepting a lawless ruling, acting solely on the basis of the bottom line, which is what the court ruled, rather than giving any critical analysis to the reasoning behind the decision, and in effect having no check on a runaway court. I would suggest to you that blind obedience to a lawless decision is a relatively modern development, the result of a fraud, frankly, perpetrated by the courts themselves, by Chief Justice Marshall in Marbury versus Madison on the federal level, and by our own Supreme Court at the state level in the case of State versus LaFrance, according to which the legislature is bound by bad rulings, and the quality of the ruling's reasoning cannot be examined and cannot be given the effect or not they deserve. All that matters, according to this view, is what the court concluded. I think this mindset needs to be changed, and if the court won't back off from Claremont by overruling Claremont 1 and Claremont 2, the legislature must take the bull by the horns and act. Thank you.
Thank you, Greg. I haven't heard a time frame yet, so I think I have time actually to take a voice question. If somebody would like to ask something out loud, I would take that. Otherwise, Mr. McGuire, Representative McGuire.
Greg, what did Claremont 2 add on top of Claremont 1? What was the main effect of Claremont 2?
Well, Claremont 1 just basically said that the state has every child has a right to an adequate education, and the state has to fund it. And what Claremont 2 was doing was quantifying the contents of an adequate education, giving hints to the legislature as to what it should consider. It was very much, the relationship between Claremont 1 and Claremont 2 on the state level and Roe versus Wade and Casey on the federal level is just incredible, because Roe versus Wade basically did the same thing. You have a right to an abortion and had that trimester program, but it stayed in generalities, where Casey came in to try to define it more closely, and it still didn't work. And Claremont 2 didn't work either, because there have been, I don't know how many Claremont cases there have been now. I think we were up to Claremont 8 at some point. And that's not even counting Londonderry and one or two others that have been along. Because every time the legislature passes an education funding bill, somebody don't like it. And anyone, if any school district anywhere in the state, or even private individuals, because the court said this is an individual right, if individuals don't like it, they have standing to go to court. So the Claremont line of cases, just like the Roe versus Wade line of cases, guarantees litigation forever.
Were there any other? Please do, Representative Bose.
Representative Michael Bose from Epping. So in 1784, New Hampshire adopted its constitution, but in 1791-92, New Hampshire convened a constitutional convention and adopted 72 amendments to the 1784 Constitution. The Speaker of the House at that time was William Plummer, and he was the man who conducted or presided over the Constitutional Convention. And supposedly, he wrote much of the text of those 72 amendments. Plummer was a voluminous writer. He's left behind, thousands and thousands of pages. that he wrote over the course of a long career. He lived to be 90 years old. Do we know if in any of Plummer's writings during that time, whether there was any discussion of what the word cherish might mean in that context, and what his interpretation and the Constitutional Convention of 1792's interpretation was at that time?
No, I don't think, and I could be correct on this. What I've read to you were what came out of the 1792 convention, and I don't think there were any changes to either Article 83 or Article 83 of Part 2 or Article 6 of Part 1. My impression of the results of that convention were to reflect changes in the nomenclature. You know, the president of New Hampshire that became the governor, that kind of thing. All I do know about that period was that the education law of 1789 came between the 1784 Constitution and the 1792, and the education law of 1789 very, very clearly followed the relationship between Article 83 and Article 6 as they read both before and after the education law, and that was state mandates to the localities to provide education, and in fact dictating to them how much they had to spend. So, but if there's anything more than that, I don't know.
We have just a few more minutes. Representative Sorg, you I believe were here when HCR 14, you remember it.
I do, yeah.
Is that the way to go? Should that be exactly what these representatives or our representatives, speaking through the podcast world, is that the way to go, to just simply repudiate it in words and say, we just resolved, this is a bunch of horse, whatever, I think we said?
Well, but I loved it at the time, and I you know, the separation of powers has been a passion of mine since I was 14, because I lived in Illinois when we saw the full effects of the U.S. Supreme Court's Reynolds versus Sims opinion, which said that states had to have electoral districts of equal populations. We've had to deal with that ever since, which had the effect in Illinois, where I grew up, of effectively turning control of the state of Illinois over to Chicago, because Chicago has so many people in it. It's so much so that there's a movement in Illinois for the southern part of the state to secede and form a new state. God, I forgot the question.
Oh, the question? No, I'm asking if you think the HCR, the HCR 14 from before the resolution, it's a resolution, declares the New Hampshire Supreme Court's decision to be unconstitutional violation of the separation of powers. Yeah. Is that a simple enough, or is there something else that you'd recommend specifically? That the general court might
I
consider?
do like that. I think the outcome of such a repudiation would be very healthy, because the courts, after all, as Hamilton said in the Federal 78, the reason the judiciary is supposedly the weakest branch is because it depends upon the legislative branch for its funding, it depends upon the executive branch for the enforcement of its decisions. All it has is judgment. Right. And so if the legislature had, and especially if they had Governor Ayotte on board with this, just said, we're not going to comply with this, it's impossible. Our constituents won't stand for it, so we're not going to do it. The court can't do anything about that. I can remember in this connection, when I was in the legislature around 2006, we were debating the education bill at that time. And I went out into the anteroom during one of the breaks, and one representative was saying to another, what happens if we don't pass an education bill like the court wants? Will we get arrested? And I was picturing Chief Justice Broderick coming in his black robes with handcuffs and telling you, hands behind your back. It's so ludicrous, but that's what people think. They're in such fear and awe of the judiciary. They think all kinds of terrible things will happen if the political branches get together and say, you've gone too far this time, we're not going to do it. The court can't do anything about that. Yeah. So I say do it. Yeah. Now, I did suggest another more elegant solution later on, I think probably in the 2011 session, and that's simply to withdraw jurisdiction from the courts to hear education funding cases. That's all. Just take away their jurisdiction to hear them.
I like this. I have to say, we're going to close this session. We're going to have a 10-minute break or so, something in there. But I have to say one last thing, I have one last question for you, Greg, and that is, somebody was asking before what writing's available, and I know you put together the Claremont Reader, which when I'm looking through it, I'm just overwhelmed by it. You said, well, sort of just pick and choose and read this and that. Well, Greg has written all sorts of really important summaries of key bits of literature that are out there. If you're a state rep and you haven't read them, you don't know these issues. Because they're from all kinds of sides and they're from all kinds of minds, really strong characters responding to all this stuff for some length of time, some serious period of time. Greg, you want to tell us about what's available, what you can make available? And you did also your amicus brief, your Conval decision.
Well, I think the brief,
is it available? Yeah.
I think the brief is online, right?
Yeah, you sent me something. I think you found it online.
But yeah. We've had two filings in the current iteration of the Claremont appeal. The Conval appeal. On September 4th, we filed a memorandum. I didn't call it an amicus brief because we already filed an amicus brief in 2020. And I filed, on behalf of our legislative amici, a memorandum for two reasons. Number one, to remind the court of the 2020 brief. Still out there, we want you to consider it. Let them know we're still looking. And also to suggest to them that they might like to take a look at the Dobbs decision and what it did with respect to Roe versus Wade and Casey, and just see if you may find this applies very well to the situation you've created with Claremont 1 and 2, and apply that reasoning to an overruling.
So where might they go?
So I could send that to you, and also, and believe it or not, when we filed that, the school districts objected. They filed a motion to strike. Imagine that. The legislators who stand to lose the most, that they just want a voice in what's being done to them, and the school districts don't want them to have any voice in what's being done to them. And so they objected. They moved to strike, and I filed an objection to the motion to strike, and the court just held it all in abeyance. They haven't ruled on it. And I'd like I'll submit both the motion to strike and the objection to the motion to strike, so it'll be available at the HRA website. Is that what you were saying?
We'll figure out a place to put it. We haven't done that. We haven't figured that out yet, but it's going to be happening. But the other thing I wanted them to be able to get access to, if it's something they can do, if they buy it from you or what, and that's the Claremont Reader. Is there a way to make that available? Is it?
I've got it all on my computer. I think it's.
You sent me an online version. I have an online version from you, I think.
Yeah, I don't have any. I may have one printed version left. We put one in every committee room back in the day.
Yes,
we put one in every committee room, and eventually they all just disappeared.
But if you give me permission, I will put that. I'll make that available for everybody to have. If you say so. If you want people to charge for it, I'll have to talk to somebody about how to do that.
A lot of this. 99% of that stuff is stuff written by other people.
I know.
I wrote introductory material to each one, and I wrote an introduction to the whole thing and a postscript to the whole thing. But a lot of the work is done by other people. I stood on the shoulders of giants, I would say. Especially Gene Van Loan, a brilliant lawyer, wrote a marvelous critique in 10 parts of Claremont. And God, I wouldn't want to charge for that because that would be, I'd get into trouble for that. It's a copyright infringement.
Okay.
I'm surprised he hasn't sued. He's a very nice fellow, but when I spoke to him years ago about this, because I found an error in one of his pieces. There'd been a line left out by a person transcribing it, and I asked him, I think there's a line missing here, and he went back to his journal. Oh yeah, there it is. And I realized then I've never asked him for permission to print this stuff, and yet
we'll have to do that.
He never raised a fuss about it. Thank goodness.
Well, this is the break.
I'm a lawyer. I should know better.
If you're as concerned as we are with the loss of the legislature's control over policy and taxation in New Hampshire and wish to help, please share these podcasts with as many people as you can, and then consider donating so we can bring you and your friends even more of the important facts concerning our Supreme Court's Claremont decisions. In the next podcast, we'll be speaking with New Hampshire's Senate Legal Counsel Rick Lehmann.